for hours with you. I believe that this is, bar none, the one place where law firms are leaving the most money on the table. So I'm going to jump right in and try to educate you as much as I possibly can to put each of you in the best position to maximize the return on the investment that the law firms are making. I will say one other thing before I jump in, which is this. 98% of what I tell you today, you already know. All right. This isn't going to be a situation where you have 100 pages of notes and go, oh my God, I didn't know any of this stuff. You know most of what I'm going to tell you. My goal here today is to get you to utilize this knowledge a little bit differently in your everyday processes and understand how valuable and effective this could be and how impactful this could be on every single call your team gets on. So that's my goal. Let's start with a little bit of a bio on me. Let's see if I can move this. Boom. I've been an attorney for 15 years. It seems like a lot less, but I guess it's, numbers say it's not. I have my own call center, intake conversion experts. I have my own consulting company. I have my own law firm. I wrote a book on intake, and I managed intake for a national PI practice known as Falcowitz, who I will always be very grateful for and appreciative to, based upon everything I learned from Jerry Parker there. So I'd be remiss if I didn't say that. Let's talk about what every law firm's goal is. We want to sign more cases without just throwing more money into marketing, right? I mean, at the end of the day, that's so easy to do, to just say, you know what, hey, we only signed 100 cases last month, or 50 cases last month, or 300 cases last month. I want more. I want double. Let me double the spend and see if that doubles the number of cases we're going to retain. The reality is that they don't go hand in hand. What law firms don't realize is how much money they're losing, how many cases they're getting, how many leads they're getting that they're losing that could have potentially doubled their inventory had they had a maximized intake process. Now, unlike other businesses, we're unable to cold call, right? We don't have the ability or the luxury to start calling up everyone we've ever met and go, hey, have you been in a car accident before? Hey, I saw there someone in your neighborhood was injured. Was that you? We don't get to do that. And that's a good thing because no one will really accept those calls comfortably anyway. But it also is a good thing because it brings ethics to the highest degree in our industry, right? In order for us to make money, we've got to spend. We've got to spend money because and we have to, our ability to sign clients is directly dependent upon our ability to respond. Now, how do we respond? We got to spend money. We've got to make sure we have a brand or that we're creating some sort of lead generation funnel so that law firms know that if and when they're ever in an accident or if and when they ever need a lawyer, they should call us and not somebody else. Now, this response power that I'm talking about, it's really powerful, right? When I talk about our ability to respond and how strong that authority is, I have to tell you right now, I want you to think for a moment that if you're a law firm and you're marketing yourself to everyone who's in a car accident, if you've recently been in a car accident and you've been injured, give us a call, we can help. You made it very, very clear that the type of person you want to sign. If you're recently in a car accident and you were injured and you're looking for a lawyer, I want you to call us. 4 very basic things. People are going to call you. People that meet that basic requirement, they're going to call you. And if we're not able to sign that case, that's on us. That's not on them. That's on us because this is what we wanted. This is what we got. And somehow we didn't create that bridge, which I'll talk about momentarily. The same thing goes with your power to create. They're calling up and they're basically asking you, hey, I think I need you. Can you provide me with the information and the steps necessary to create this relationship without overwhelming me, without intimidating me, without making me feel like it's the wrong decision, right? So that power to be able to pick up that phone call or outbound a phone call on a web lead, that ability, whatever you do on that first call is tremendously impactful one way or the other. And if there's one thing you take from this webinar or this Zoom today, if there's one thing, it's this. If you lose cases, I want you to look in the mirror and ask yourselves why. What could we have done differently? It's so easy to go, they were high maintenance. or they didn't really have the answers to their questions. They didn't have the police report on them. They don't know if it's broken or not. It's so easy to just shift the blame on somebody else and say, yeah, it wasn't really what we wanted anyway. The reality is, if you want to improve in anything, in any business, in your industry, as an intake specialist, as a lawyer, you've got to constantly have an accountability check and go, but was there something we could have done differently? Could we have answered the call faster? Could we have answered their questions better? Could we have gotten a lawyer on the telephone? Could we have told them the benefits of signing with our law firm compared to another law firm? You've got to ask yourself those questions if you really want to grow in your business. Now, in order to have opportunities to respond, like I said, we need to market. The good news is you're working with one of the strongest legal marketing brands in the industry in Law Tigers. You guys know this. You don't need me to tell you that. The bad news is they and you are not the only game in town. Did you know that according to Search Engine Watch, 19 of the top 25 most expensive keywords on Google are searches related to personal injury law firms? Now, I know that the lawyers out there, you guys know what all this means. You know what PPC and all those other things mean. For those of you, for you intake specialists or you associates out there, I need you to understand something. When you Google any term, there are only so many results that pop up on the first page. And we all of us, as a group and individually, when we're Googling something, rarely do we click on next page, and then call somebody in the third page. Rarely. What we usually do is take one of the first 2, 3, or 4, or 5 options or results, and we call them up. Now, that's really competitive. To have hundreds of personal injury law firms wanting to pop up for the term mesothelioma lawyer, right? That can get expensive. How expensive? Almost, this is old, by the way, so it's probably more. Almost $1,000 per click. Gary, what does that mean? That means that people will be that law firms will be paying Google $1,000 every time somebody clicks on their website, when their website shows up as a result when someone is Googling in the terms mesothelioma, best mesothelioma lawyer. Now, that does not mean they're paying $1,000 for a new client. That does not mean they're paying $1,000 for someone who's qualified. That does not even mean they're paying $1,000 for someone who has ever been diagnosed with mesothelioma. What that means is that if someone is even looking at your website and they click on it from a results page that you paid to show up on, your law firm's paying $1,000. Why do I tell you this? I tell you this because it's competitive. I need to constantly remind law firms, whether they're working with my consulting company, with my answering service, it doesn't matter. I need to constantly remind you guys how competitive this is. Why am I telling you how competitive it is? To justify the spend? No, to make sure you understand that the next step, whatever that next step is, whoever you have in place for that next step, that is the most important next step if you're going to spend money marketing. Now, let's ask the obvious question. Why? Why are we spending so much money in marketing? Well, here are the 3 obvious reasons. One is our success rate to earn a fee from a retained case is, and obviously should be, very high. What do I mean by that? I mean, most of the people we sign, we're helping. Most of the people we sign, we're getting them money. And obviously, we're earning a fee and helping our business, right? So our success rates are really high. Number 2, the more we help people, the more we earn, the more we invest. Very simple. The more money we make, the more we're going to spend money, the more we're going to spend marketing, hopefully the more cases we're going to get. And this is the one that people don't realize, and it's so important. It's because we believe in our intake. If you did not have an intake team, if you want to call it a sales team, intake team, whatever you opening team, whatever you want to call it, if you did not have a strong team at your intake level, there's no way ever the owners in your law firm are going to spend the money they're spending. So they may not say it. They may not say thank you enough. They may not give you enough credit. They may not talk about it at dinner because it's not the most sexy conversation to talk about. But I promise you, if they did not believe in your intake ability, they would not be spending what they're spending. It's really important everybody understands that. Now, we need to always assess how good or bad our industry is at intake and conversion. I talked about this momentarily a few moments ago, which is that whole accountability thing. We have to constantly look into what we're good at, what we're bad at, what we can improve upon, and what we can't improve upon. whether we have to outsource something, whether we need more staff, whether we're listening to calls. I'll get into some of these things momentarily. But the best metric available to assess our intake is conversion percentage. I'll tell you one more what that is. Conversion percentage. The thing about conversion percentage is this. Most law firms don't know what it is. I don't mean don't know what the definition is. I think most lawyers, especially this day and age, I've been lecturing on this for 5 years. So lawyers, if you ever came in anywhere near me, you know what conversion percentage is. But what most lawyers don't know is what their conversion percentage is, what it really is. Not what they think it is, not what it ought to be, what it really is. Gary, what do you mean when you talk about conversion percentage? When I refer to conversion percentage, this is what I mean. If I had 1,000 leads, 1,000 leads were generated from my law firm, and 500 of those qualified, which would be a really high qualification rate, but we'll talk about that in a moment. 500 qualified. If only 250 of those signed, my conversion rate is 50%. In other words, 250 out of the 500 that I wanted to sign, 250 out of the 500 that qualified for representation, 50% of the cases that I wanted signed. That's your conversion percentage. You need to know this. Yes, do other marketers or consultants or owners of law firms tell you, yeah, but what's my cost per lead and my cost per retainer and what's my retention percentage on leads? Yeah, all that's relevant, and we could move the numbers around so they look sexier for us or look better for us. But the reality is, what we need to know is, hey, of all the cases that I wanted to sign, how many did I sign? What percentage? And then we get to look back and go, so if I signed 50% of what I wanted, that means I lost 50% of what I wanted, which now means I have a reason to go look into and open up every single case that I wanted and lost and look into why. That is the best part about when I work with law firms or even talk to law firms, the one aspect or one responsibility that I really put on their shoulders is now go back every week and look at all the cases that you wanted and lost. Open them up. I want you to start asking questions to your team. Hey, lead came in at 6:30 on a Friday evening. Why does it look like our first call was Monday morning? Do we not have weekend staff? Or do we not have someone working on 6:30 on Monday evening even from home to call that up? Hey, I'm looking at this lead, and it looks like we qualified it, but we didn't send out an electronic retainer until the next day. How come? Why didn't we send it out? Why didn't we talk to them on the phone and try to get signed while we were speaking with them? These are the questions you need to start asking yourself, because 20 years ago, and probably less, but let's say 20 years ago. 20 years ago, a lawyer can get a call on their cell phone on a Friday evening, and it could be a pretty good case. And you can have a great conversation with that claimant. And you can tell that claimant, Mrs. Jones, I'm out to dinner with my wife right now. We're celebrating our anniversary. This seems like something we think we can help you out with. Can I give you a call back Monday morning and we can talk about the next steps and get you signed up? And 20 years ago, I bet there's an 80% chance you get that case signed, right? You gave them your time and you had a conversation with them. You told them you got personable. You told them with your wife and you move on. Monday morning, you likely sign that case up. You try that now there's an 80% chance you'll lose it, okay? Because we're in a day and age, and I'll talk about the mentality of the claimant in a moment, but we're in a day and age where people, they're not looking into the stats that you want them to look into. They're not looking into how many lawyers do you have? How much money did you make last year? How much money are you going to get me for this case? They want someone to take that case off their shoulders and put it on your shoulders as fast as possible. And they don't care if you're a solo practitioner or you have 100 lawyers. I promise you, if they called you and you're fast and you make a decision, they're going to sign. There's a strong likelihood they're going to sign with you. So getting back to this conversion percentage, here's my example that I want you guys to understand some of these percentages. If I have 500 leads and 100 qualify and 50 retained, we know my want percentage, which is a very good marketing statistic. We know that my want percentage is 20%. In other words, you can go back to your marketer and say, hey guys, you got us 500 leads last month, but only 100 of them qualified. And looking back at the 3 months prior, it was closer to about 35 to 40% that qualified. What happened last month? That's how you hold your marketer accountable. You have to know, because they have no impact on your ability to sign cases, but they do have an impact on and trying to get you qualified cases. And if you don't know your qualification rate or your want rate on a month-to-month basis, then you can't go back to them with any real questions. You can't go back to the cost per retainer. That's not on them. Your conversion percentage, we just talked about this. 50 out of 100 that you want signed, that's a 50%. Your retained percentage, law firms love this. I don't like it. I don't think it provides much detail for me, but some people like to know, hey, what percentage of my leads signed? Okay, 10%. On average, guys, I use numbers. The retained percentage is actually what I'm seeing on average, about 10% of the leads. I'll get into some other averages in about 30 seconds. But those are the percentages I want you to understand, especially if you're in any sort of management role for your law firm. If you're in an ownership role of your law firm, you should be having these reports emailed to you on a nightly and certainly a weekly basis. You need to know, how many leads do we get? How many qualified? How many do we sign? What was our qualification rate? What was our conversion rate? If you want the retention rate, go right ahead. You need this information. This is the true heartbeat of your law firm. You'll know if it's going too fast. Like, oh, guys, something's wrong, going too slow. You got to know if things are moving the way they're supposed to be moving. And then the best part about it is you know when there's a red flag, right? How come our conversion rate last month was 50%? That's an issue, guys. Are we fixing this issue? Do you know what the problem is? Let's go over some more numbers. The average conversion percentage for personal injury law firms that do general negligence cases and that are handling the intake themselves is between 70 and 75%. For mass torts, it's between 50 and 60%. Now, those numbers are from me. Those numbers are from the consulting with dozens of law firms nationwide. It's from having law firms outsource their intake to my call center and asking those questions. Those are weak numbers. We are so much better than that. Think about the numbers I just told you. What I just told you, and some of you might be great, but I've worked with law firms that are at 97, 98% conversion rate, no joke, and they're signing almost 400 cases a month. No joke. Everything I'm saying is from experience. So when I see an average conversion rate of 70 to 75%, my first thought is, how is that possible? Why is it that law firms market for this and people who have this call up, and yet we're only converting 3/4 of them? If you're doing local PI, you should be above 90% every month. No exceptions. Mass torts, nationwide, not much of a local brand or presence that is nationally recognized. For that reason, it's going to be a lower conversion rate. But 50 to 60%, that means that you're losing 40 to 50% of the cases that you want to sign. You guys have to understand these numbers. You have to dig deep in your own firms so you know where the numbers are, where they ought to be, and if they're not where they ought to be, why? Asking that why question. So asking why are the numbers so low? Very simple. Competition is intense, and we have too many leaks in our process. That's it. Generally speaking, that's what it is. And we're not accepting of either one of those. We're either ignorant to the fact that the law firm next door that's so much smaller is actually a competitor, or we're ignorant to the fact that we have a lot of holes in our system and we don't care about it because we're making money anyway. Either way, that's the reason why the numbers are so low. We didn't talk about this. Where should the conversion be? We did. General negligence, greater than 90%. Mass tort should be greater than 75%. In other words, there's tremendous room for growth. But in order to improve, you need to know your weaknesses. This is a list of the weaknesses that I see and I have seen that I know exist nationwide. Okay? This doesn't mean that you fall into each one of these, but if I were you after this call today, I'd sit back with your team and go, let's go through these things. Where are our weaknesses? Where are we falling here, right? Wrong person on the phone, maybe not dedicated. When I say wrong person on the phone, I could be talking about personality, right? If you're not listening to calls, and you don't know the personality that your intake team is displaying, that's an issue. Maybe you have people doing intake that are doing other things as well. And for that reason, intake is not their number one priority. Got to get that fixed. Inadequate guidelines and procedures. Exactly what it sounds like. Do you have guidelines and procedures? Do you have a booklet so that when you have a new trainee or a new hire that comes in, that they're reading and they know exactly what the statuses are and they know exactly what to do and what the scripting is? If you don't, you got to create one. Not listening to calls at all or enough. I will tell you this without any hesitation. When I was back at the law firm and I was managing the intake team at Parker Wakeman, when I first realized that we had these calls recorded and we should start listening to them, my first reaction was, damn, that's going to be a lot of time out of my schedule. But I hope it's not a waste. And I got to tell you, from the first call on, I realized how valuable that was. Every single phone call can be improved upon. Every single phone call can be improved. Even if the case is signed, you listen to that call and you go, he or she could have answered that question better. We could have said, the reason for the hold or the silence. We could have told them why we couldn't handle the case. But every single call can be improved upon. And until you start to listen to calls and then hold your team accountable, then they're just going to continue to do the same thing over and over again. I remember listening to one call where an intake specialist flat out told a claimant that because it was rainy weather, you would not be able to hold someone else responsible for the accident and the injuries that you suffered, and that the law firm couldn't help out. I was like, oh God, I can't believe I heard that. Now I have to go call the lawyer up and go talk to them about this case. All right, but at the end of the day, if you don't listen, you have no idea that that's happening. So please, please, please start considering listening to calls. You can't hear them all. You don't have the staff to do that, but at least, a random number of calls and then critiquing those calls with your intake team so that they know what they sound like. That's when you start to improve the most. Outdated technology. You guys know what technology is out there. If you're working with a program or a product that is old and you keep trying to find exceptions and workarounds, that's an issue. That's going to slow your team down. And we can't. With intake, you guys, you're working with law tigers. Most of you are probably, fast-moving, large, very successful law firms. You cannot have your intake team work with an antiquated system and then expect them to have the best results. It's not going to work. Not understanding the claimant's mentality. I'm going to talk about that in more detail in a moment, so no need to get into that right now. Nights and weekends are neglected. It's that simple. This is not a 9-to-5 job. It has changed years ago. It is changing more every single day. You need to have people available in the evenings who can sign cases electronically. You need to have people who are making follow-up calls on the weekends. If you're going to use an answering service, you better make sure that answering service is qualifying cases and warm transferring those qualified cases to someone within your law firm, rather than you just getting an email and saying, oh, great, we got a qualified MISO case. Let me go call them up. Because when you call them up, they're going to tell you, oh, I just signed with a different law firm, right? So you got to think about these things. If you anticipate the level of competition that's out there, you're going to react better. If you think it's nothing, then your reaction is going to be weak and slow and inappropriate. Lack of attorney involvement. I remember when I first got on the entrepreneur scene and I started my own company, and I would have conversations or debates with other lawyers about whether attorney involvement is a thing at intake. I hope and believe that now most lawyers understand and appreciate the additional value that a lawyer's involvement can have at intake. Does that mean that your lawyers should pick up new calls? No, that's not my argument. My argument is that if you have a qualified case on the phone and there's any, at the very least, and there's any indication of hesitation, you better be offering the ability to speak to a lawyer. And by the way, if you have the resources, don't wait for that hesitation. In an ideal world, if I had my tremendous practice and I had the resources available to me, I would have a lawyer, an intake lawyer, who spoke to every qualified claimant. Why? Because when you compare it to two other law firms and you're the only one that put a lawyer on the phone, you win. And at the end of the day, this game, I want to win as much as possible. And I think you guys want to as well. Not considering appropriate vendors, exactly how it sounds. It's similar to outdated technology. Not giving your staff authority to make a decision on the first call. This one is a big issue in our industry. For whatever reason, law firms are hesitant about allowing their intake staff to make decisions about whether a case qualifies or not, and rather, they would prefer to either put that claimant on hold or tell that claimant that someone's going to call them back and let them know whether that case qualifies or not. There's no room for this, guys. There's no room for this. We have sometimes where we have one bite at the apple. So how dare us think that we have the luxury to tell somebody, thanks for that information. I'll get back to you in a little bit after I speak to the lawyer to see whether you qualify. Take the chance, give your people the authority to make that decision, allow them to err on the side of qualifying somebody as opposed to erroneously disqualifying somebody, and then don't get them in trouble or discipline them if they qualified inappropriately. The whole point is they're trying to maximize the return on your marketing investment, which requires them to get this person, I'll use like a free agent, sports analogy, get them off the market as fast as possible. Don't allow them to go shop other law firms. By the way, what's the worst case that can happen? This is the best question. What's the worst that can happen? If you qualify and sign a case you shouldn't have qualified and signed. In reality, you have to send out a reject letter. You got to call them up. Now, the problem is most law firms aren't quick enough to review the case immediately post-retention. Then now that case gets stuck in no man's land for 1, 2, 3, 4, 5, 6 months, and then they get mad at intake. Why did you sign this case 6 months ago? Well, no, that's not the question they ask. The question is, why didn't we review this case immediately upon retaining the case to make sure it's really one we wanted? We signed it because we wanted them off the market, and it met the most basic criteria we needed to sign that case. So we got to fix our own mentality sometimes. Not categorizing or statusing appropriately, not monetizing referrals, which is a huge one. Not monetizing. Guys, if it's not a case you handle before you reject it, consider whether it's an employment case, whether it's a small value case and you know a law firm that handles small value cases, whether it happened in another state and you know other law firms in other states. We have this cool thing called referral fees that I'm a beneficiary of, that most of you should be a beneficiary of. And we should be capitalizing on that as much as possible. Quite frankly, we shouldn't reject any cases until we squeeze that towel dry to ensure there's no value there. And that's where referrals come into play. Poor intake culture. This is a big one. This is one of those things where you may not realize that it exists until you dig a little deep and you have some discussions with your intake team. Being an intake specialist at a law firm is a thankless position with constant demands, constant changes, and a high level of expectation. And by the way, they're not the highest paid staff in your firm also. So you've got to really make sure that they're as comfortable with what they're doing in a day-to-day job and that they understand what the expectations are and that they're happy and that happiness is overflowing in these calls. Because if they're not, it's going to have an immediate and significant and negative impact on intake and obviously on your ROI. Pardon me for 1 sec. Sorry, you might hear my kids in the background. These working from home is always fun. Okay, now what we're not conveying on the calls. We may not be conveying interest. We may not be conveying urgency. We may not be conveying compassion, reassurance, or roadmap. I want to talk about the last two, reassurance and a roadmap. When claimants call us, in the back of their minds, even the broken elbow, rear end, great liability UPS truck, doesn't matter. In the back of their mind, they're thinking, can they help me? Did I do the right thing by calling? Right? We cannot assume that our claimants are educated enough to know that when they call, they know they have a case, or they know what that case is worth, or they know what liability means, or they know what causation means, or they know what deep pockets mean. We have to assume the complete opposite. We have to assume that they're calling us because they're not really sure. They see these commercials, they see all these numbers thrown around in the commercials. We've resolved $300 million. They see that and they're not really sure. They need to be reassured that they did the right thing by calling. And we've got to say that, Mrs. Jones, you did the right thing by calling. We handle cases like yours every single day. We've got to say that. And then the roadmap, here's the thing about the roadmap. The phone call is going down a path they've never had to go down before. Most people in this world will never need a personal injury lawyer. Never. right? I would say 90% of the people in any room will never need a personal injury lawyer. I made that number up, but I'll stand by it. And then the ones that did need a personal injury lawyer, the majority of them will never need it twice, which means that most people who call a personal injury lawyer will only need one in their lifetime, right? I mean, convince me I'm wrong. Convince me that someone needs five times in their life personal injury lawyer. What's my point? Gary, what's your point? My point is this. They have no idea what to expect on this phone call. Let's provide a roadmap. Mr. Jones, you did the right thing by calling. It's exactly the type of case we handle. What I'm going to do now is I'm going to gather your contact information, and then I'm going to ask you a few more questions to make sure you qualify. After that, after you qualify, because it seems like you will, I'm going to ask you a few more questions to make sure I have all the details. Then I'm going to tell you how you become a client, and we're going to start this investigation for you. I just totally managed expectations for what's going to happen on this phone call. And if we don't do that at the outset of that phone call, then this claimant is constantly thinking, well, do they want my case? Why they ask me that question? What does that mean? What should I answer here? I don't even know if this is it. Is this a waste of my time? What is retaining me? I mean, we've got to set it out at the outset what those expectations for that phone call should be. Last few things here, the reasons why the numbers are so low: lack of accountability or management, not tracking key performance indicators / statistics, and then not investigating the black holes. By the way, there will be an opportunity at the end of this call for any questions, so I'm going to go a little bit fast here because I tend to, like I said, I could talk about this for a long time. Okay, so what are the real reasons why claimants choose our competitors over us? We have to look in the mirror. First step here is catching them all. We have to use a large net. Second step is rushing to judgment, shot clock. Third step is convincing them to sign. The fourth step is staying accountable to the process. First step, catch them all. 99% of our leads have some value, even if it's not a case that your law firm will handle internally. What can that value be? Future marketing opportunities, good customer service, results in referrals and leaves a positive impact. What once seemed like no case might actually become one. I got to tell you, one thing I love doing with law firms is I'll tell them, if somebody calls you up, but they have a minor injury and the accident just happened, do me a favor and calendar to call them back in 1 week, because that injury may have actually presented itself differently a week later, and we want to sign that case if it did. So that's why I'm talking about a case can come in not being of value and then become one of value. Could be a referral for a different case type or a law firm. Get your contact information in their cell phone and make sure they think of you in the future. This one is such a huge opportunity that very few law firms are capitalizing on. If I asked everyone here, if your air conditioning broke tonight, where would you go to find an air conditioning guy? Most of you would not go to Google. Most of you would either go on your phones because you already have the AC guy saved in your phone, or you would text your buddies who live in the same area and say, you have a good AC guy. Same thing goes for personal injury lawyers. If somebody gets hurt, they may be moving away from Google and they look at, oh, you know, there's one I used 4 years ago. I got this still have it saved in my phone. Or they're going to text their buddies, and their buddies are going to say, oh, I got a good PI lawyer. Let me forward you his contact. Get your contact in their phones. And lastly, it's data mining for the future. Second step, rush to judgment. You may not take your time. In my book, I say it's better to retain than reject than never to retain at all. Okay? Let's keep it very simple intake. There's no room for callbacks, but of course you're going to have to do a lot of calling back and following up. There's no room for delays in decision making, no room for fence sitting. Retain, then investigate. Not investigate, then retain. I can't stand it when I hear a call from a law firm and they say, well, can you get that police report for us? Can you let us know whether the doctor said it was a fracture or not? Forget all that stuff. Let's take the claimant's word for it. Worst case scenario, we reject it post-retention. And lastly, because you're in a competition. Third step, convince them to sign. If a desperate person needed to cross one of these bridges to survive, which would they choose? We all know the answer, right? This is not rocket science. They would choose the one that looks like a walking escalator, if you will, at an airport. Why? Because the more attractive your bridge is, the easier it is to cross, the more desirable you make the destination, the more interested they'll be in crossing it. If you make it difficult, if you tell them in this COVID world, well, the only way we can sign you up is to have someone come into your house, Nah, forget it. I'm not going to go with you guys. You have to make it desirable. You have to make it easy. You have to make it attractive. How do we create the best bridge? This is my favorite analogy. For those of you who have played blackjack, bear with me for a moment. For those who have not played blackjack, all you have to understand is the following. Your job in blackjack is to beat the dealer. And the dealer has a card that's face down. You can see the dealer right in this illustration here. There's that one card in front of the dealer that has the green back. It's face down. The whole point is you have to make an assumption. There are rules in blackjack, whether you're going to hit or stay, based upon an assumption. That assumption is that that green card that's face down is a 10, and then everything goes from there. But you assume that that card is a 10. Well, there's a similar assumption for law firms, and it's this. I want you to assume that you are the third law firm that the claimant is contacting. I want you to assume they spoke with two other law firms, and they're comparing what you have to say, how you have to say it, who they're speaking with, to two other law firms. If you do that, I promise your team will start to hold themselves more accountable. If you take on the entitled perspective of, hey, they called us, so obviously they want us, you're going to lose. You're going to hurt. You're going to miss cases. I need everyone to understand that regardless of how successful you are, your intake team must understand that there are other games in town. Okay, keep going here. Fourth step is accountability. Knowing your metrics, having alarms in place, comparing and contrasting, and then seeking improvements everywhere. Here are my KPIs I want you guys to be aware of. I want you to know your want percentage, your conversion percentage. We talked about the retained percentage. I don't love that one. Average time to follow up on web leads, average number of attempts before quitting, mail out percentage versus electronic signature versus in-person at firm versus in-person not at firm. Average sign-up time between qualifying and signing and between lead and signing. I want you to know your retained and rejected percentage. That's a big one. Gary, why do you have to know retained and rejected? Well, that's going to tell you how intake's doing. If you end up retaining then rejecting 80% of the cases that you're retaining, there's an issue, is a big issue. And now let's go the other way around. If you're retaining then rejecting only 1% of the cases you reject, don't look at yourself and pat yourself in the back. Wonder, I think maybe we can have a looser criteria here because we're not rejecting anything post-retention. Let's try that. Let's be a little riskier over here. I want you to know your average number of cases qualified in the first call, average number of qualified leads retained electronically in the first call. Guys, if you're not signing electronically, I'm gonna take a leap here and just assume that every law firm that's listening to this is using electronic retainer. And if you're not, I want you to put a poker face on and tell people that you are, because you need to be. You need to be. Now, that being said, not only do you need to be using electronic retainer, your team needs to be signing cases while on the first call. I love when that happens. I love when my team is signing people up on the first time we speak with them, during the first time we speak with them. You know what, Mrs. Jones? Based on everything you told me, you qualify. Do you have a smartphone? Sure I do. Great. I'm going to send you an email and text right now. It's going to have the retainer. Don't worry, there's no cost to signing this. There's no credit card. It's all contingency fee. And I'm going to stay on the phone with you to give you confirmation that you signed it. So when you hang up this call, you're going to know we're beginning the investigation today on your behalf. That's what I want. I want those cases signed on the first call. And then I want to know all the reasons claimants provided for not proceeding. Let's go to the next one here. The claimant's mentality. We are in a crazy day and age right now. We are in an instant and immediate gratification stage. We want answers and we want them now. We want decisions made now. We want results now. We want to make purchases now. We want to send, we want to send mail. We want everything done this minute. We're not patient anymore, right? So we have to understand that when claimants call us, they really wanted a decision from us now. The interest level is highest during their first contact. Listen, guys, I know I need to go to the gym. If I go into a gym, which I'm not going to do with COVID right now, but before COVID, if I went to a gym and I asked about their membership, and I asked about their workout equipment, and I asked about their instructors and everything else, I'm most interested when I'm standing in front of them in that gym. The moment I leave, I got distractions. I got other things going on in my life, and they better follow up with me to reinvest and bring back my interest. But the reality is my interest is highest when I walk into their building. A claimant's interest is highest when they call us, right? Let's not lose that. They're looking for reassurance. They have questions. I don't care how educated they are. I don't care how many times they've been in an accident. They've rarely needed to speak with a personal injury law firm. So we need to reassure them they did the right thing. They're looking for clear and easy steps to take. We cannot complicate it for them. They don't want to be intimidated. They want to form a trusting relationship. They don't want to be a number of how many people. Oh, you represent thousands of people, so I'm probably going to get lost, right? They don't want that. They want you to listen. No one, how much do we hate when we're speaking to someone on the telephone and we tell them this story, then they ask a question, but the answer to that question I just told you in the story, right? So we better be listening. They want their questions answered. We cannot ignore their questions. They want to be reminded. As much as their interest level is highest that first day when I go into the gym or that first time they call you, they need to be reminded. They have other things going on in their life. Do not take their silence. Do not take the fact that they haven't called you in a few days as some sort of inference that they don't want to move forward. Quite frankly, they may have a sick mother, grandmother, friend, or kid or something going on in their life that they believe is so much more important than thinking about who they should hire for their rear end case, no matter how serious their injury is. They will tell you if they're not interested. By the way, they'll even tell you why. When someone says, yeah, you know what, thank you, but no thank you, follow up that remark with, Mrs. Jones, before I let you go, can I ask you why? Why did you decide not to go with our law firm? Oh, yeah, because the last person I spoke with told me it wasn't going to be worth it. Oh, they did. Great. Or because the person I spoke with basically told me, cursed me out because I was in a rush and I didn't have time for them. Right? Oh, good to know. Thank you. Like, ask them why. Oh, it's another law firm because they went the lower contingency fee, or because they told me that they're closer to me in location. Oh, wait, Mrs. Jones, this day and age, location it's not important anymore. The fact that I could Zoom you, I can call you, we represent claimants throughout the country, right? That's not true anymore. 25 years ago, that was true, but now you may never even have to see us. You're busy, right? So it's important you find out why, because maybe you have a response that brings them back in. By the way, lots of claimants, pardon me, guys, they think their case isn't even large enough for you, right? There are people who have that broken arm or that broken foot, but because their foot wasn't chopped off or their arm, was going to heal on its own in 6 months, the law firm probably doesn't want this case. They don't know that the case could be worth $150,000 or $200,000, right? So we've got to tell them, no, we handle cases just like yours. And then here comes a reputation. The attorneys have such a bad reputation. They're just out to get money from me. We've got to remind them, guys, as much as the term contingency fee is thrown around in our industry, and everyone on this call knows exactly what our industry and what our business is like, claimants don't know that. We've got to spell it out for them. Ma'am, I'm not asking for a check. We're not asking for credit card information. We're not asking for your bank information. This is strictly a situation where the firm only gets paid if they're successful. We could work on your case for 3 years. And if we don't get you any money, you're not going to owe us any money. It's that simple. I wish the doctors were that way. I wish my mechanic was that way. But the law states requires that we only are allowed to get paid if we're successful. We've got to spell it out for them. And then they get nervous about not wanting to testify, not wanting to go to trial. Spell it out for them. Their experience is mostly from what they see on TV. Okay, dangerous traps. We called and left 3 messages. They're obviously not interested. Not true. The phone number they provided isn't working. It was obviously a fake lead. Not true. This day and age, you can have a cell phone. You pay for X amount of minutes. When those minutes are done, cell phone doesn't work anymore. Getting a phone number is enough contact information. Totally not true. Get that email address. Get that physical address. Get a second phone number. They didn't show up for their scheduled appointment. Let's stop wasting our time. Not true. Again, distractions. Distractions. Do not give up so quickly because you're upset by the high maintenance nature of a claimant. Which brings me to the next one. If they're difficult at the intake stage, they'll be difficult as a client. I cannot stand when a lawyer tells me that. I cannot stand that. They're difficult at intake because I've never had to do this before. They've never been injured, required a lawyer, then went through that process, and they had to sign some document that had 2 pages worth of small print, yet you're telling them on the telephone, it's just a contingency fee. You're not going to owe any money, unless we're successful. Then why are there 2 pages of 140 lines of other things? They're intimidated. They're nervous. We've got to make it easy for them. And by the way, the shorter you can make your retainer, regardless, listen, we're lawyers. I get it. We want to protect ourselves. And there was that one time with the guy who did this. And now I got to put a paragraph in my retainer because of that one guy. We got to be careful because the longer your retainer is, the smaller it is, the more information that's in there because you're trying to cover your butt for some crazy situation. If they compare that to the person who has a 1-page retainer that keeps it very simple, you might lose. Limited damage. And by the way, do not take any of this. I'm not an ethics expert. I'm not giving you my ethics opinion. I'm giving you my opinion based upon my experiences within the industry. Limited damage to a vehicle means limited value. Maybe in some states, I have one of my closest friends, he's the anomaly. He's needed a personal injury lawyer probably 4 or 5 times in his life. And one of the cases, he had very little damage to a rear end, hurt his neck, needed 2 surgeries, case settled for over $400,000. So we got to be careful, when you have your intake team, where there's an injury and a significant enough injury, and yet there's no damage to the car, there's minimal damage, all of a sudden we're not going to take that case because there might be someone else who does, and that someone else might be making a lot of money and might be helping that claimant out. If it's out of my jurisdiction, let's reject it. Come on, stop that. If it's not the type of case we handle, let's reject it. My paralegals can handle the intake responsibility. Be careful with that. My intake team can handle other responsibilities. Be careful with that as well. As long as I have an answering service for the nights and weekends, I'm okay. That's a good first step, right? You got to have an answering service nights and weekends. But if and when you have the resources to do it yourself, make the change, guys. Your team is always going to be better, right? And I'm even saying that to you as the president of Intake Conversion Experts. But I'm telling you, your shop is going to be better at it. If you can't, then make sure you're using somebody else. Weekend staff, are you nuts? I'm not nuts. It's required. If you're big enough, if you're getting the leads, and let's call it like minimal 10 leads on a Saturday. I mean, you should be thinking of 10 real leads. You should be thinking about someone on the weekends. Keep my attorneys away from intake. Be careful because if one of those other competitors puts a lawyer on the phone, you probably lose. We signed the most cases we've ever signed last month. We're obviously crushing it. No, look at the numbers. Know your conversion rate. Know what qualified. Then you'll know if you're crushing it or not. Some statistics to consider when evaluating your intake. Only 10% of salespeople make more than 3 contacts. That is mind-blowing. Mind-blowing. 80% of sales are made on the 5th to 12th contact. Now, I don't think this is speaking about personal injury claimants per se, but I leave it in here because I don't want you giving up after 4 contacts. I want you going 5th, 6th, 7th, 8th, 9th, 10th. Keep going. Until someone tells me I'm not interested or I go a significant period of time with silence, I'm going to keep going. Only 13% of customers believe a salesperson can understand their need. I buy that. 30 to 50% of sales go to the vendor that responds first. That's big in our industry. Huge in our industry. You cannot disregard that. Do not think that 30 minutes is good enough. It's not. If you follow up within web leads within 5 minutes, you're 9 times more likely to convert them. That's nights. That's weekends. I make it an exception for my intake team. We won't follow up past 10 p.m. at night and not before 8 a.m. Just because there are some people that think it's rude, even though they just put the lead in at 11:15 at night. Why did you call me at 11:15? Because you just put the lead in. Okay, sorry. 80% of calls go to voicemail. 90% of first-time voicemails are never returned. Make sure the words you're using in your voicemail are clear. Gary, that's so simplistic. Why are you telling me that? Why am I telling you this? Because these days, if you're like me, you're not even listening to voicemails anymore. You're now reading the transcription of the voicemail. So your words that you're using in your voicemail better be clear. They better be polite. They better be articulate. They better be clear about what you want from the claimant. The number better be clear. How much does it suck when you look at that transcription and you go, the number didn't come through. Damn it, now I got to go listen to the call, or maybe I can't do the call back because it came from a different phone number. The number they left is different. I mean, make sure that voicemail is clear. Car dealership. Why do I put a picture of a car dealership here? Because anytime you walk into a car dealership, you sit down with a salesperson. You do this whole 30-minute negotiation with them. You feel great about yourself. And you say, okay, you know what? I'll think about what we just talked about and I'll get back to you. The salesman says, whoa, Mr. Falcowitz, before you leave, I'd like to introduce you to our manager. If anyone that was thinking about that, you get a few extra points. Introduce you to our manager. Sure, I have a few more minutes. Manager comes by. Why? Because the manager and the salesman does not want me to leave. They do not want me to leave until the keys are in my hand and a check is in theirs. So use their manager analogy as a lawyer in our situation. If we have a qualified claimant, how dare us not even consider getting a lawyer on the phone to make sure before that claimant hangs up that telephone, let me get a lawyer on the phone. Maybe we can get them signed right now. Electronic retainer, and then the little pieces of gold. Guys, this is all the non-obvious stuff. This is the referrals. This is reviewing your conversion rate. This is reviewing all the leads that you wanted to sign, but you didn't sign. Why not? When you put it all together, it's probably just as much revenue as everything else. So all that being said, game on. That is the end of the presentation. So I'm going to ask or allow any and all of you to unmute. And if you have any questions, it would be my pleasure to try to answer them for you.
Hey, real quick, Gary, I have a couple notes and just to get things started here. You said that 10% sign-up rate is kind of an industry standard. So are you saying for every like 10 qualified leads or 10 just general leads, the sign-up rate is 1 in 10? Can you?
Yeah, just you know what? It's a crazy number, Ari. I didn't want to harp on it too much because I've seen law firms that have a 30% retention rate, which means that 30% of the leads they get, they're signing really high, really high. And then I've seen some as low as 5% of the leads. It doesn't tell you much because it tells you more about you might be marketing for so many different things, but really just want a little of this. And it's I wouldn't put too much stock into that. I'm more interested in knowing the conversion rate, which is of all those cases that qualified, how many did you sign? That's the value of stuff.
What on that qualification rate? Let's say, we brought in 10 leads. They said they wanted, 4 of them. What is a reasonable conversion rate on that? Is it 80%, 90%?
For local cases, your goal is to be over 90%. For local PI cases, it should be over 90% of the cases that qualify, you should sign. Why? Because you have a local brand, because they meet your criteria and they reached out to you. I mean, it's here it is. It's exactly what you wanted. It's exactly what you marketed. You're close to me. Sign me up, right? So it should be greater than 90%.
Thank you.
Falcowitz, I got a couple of questions for you. How you doing, brother?
I'm great, Paul. How are you, buddy?
Doing good. Hey, so when you indicate 90% for general negligence cases or auto cases and 75% for mass tort cases, and you did talk about, but you didn't give us a number regarding in the Law Tigers world, I believe we call it a fizzle rate, a case that you take that eventually fizzles out for some reason, no insurance, liability, whatever. You called it the retain then regret percentage. I can make my acceptance rate over 100%. I'll take a whole bunch of cases I don't ever want. And I'm kidding with that number, but my point is, you can fudge the numbers, and that's why you got to look at a whole bunch of different numbers all the time to kind of gauge these other numbers. But what do you think is a good retained then reject rate? I mean, what are you thinking?
Yeah, by the way, you said retain then regret, but I like that too. But it's retain then reject. That number better not be more than 10 or 15%, because then you're making a mistake at intake. If it's up to 10%, it really depends upon what your rejection process is like. If you're making, if you're making it significant, if it's taking your team 3 months to figure out when to reject that case. Here's what makes me nervous. So to answer your question, I'm hoping it's less than 10%. But here's the real question that I want everybody to be aware of. It's not if you did any amount of investigation on that case post-retention. You ordered the police report. You ordered the medical record. You called the doctor. Any amount of investigation, then it doesn't matter. then your team, then your intake team did the right thing because your retention team actually investigated something there, and maybe the claimant wasn't honest about something. Maybe you took a chance on it because there was no police report completed yet. It's the ones where you retain it and then almost immediately reject it. Those are the ones that are concerning to me, because what I wonder to myself is, why didn't we know that at intake? Was there a question we didn't ask at intake that we should have asked? Was there an indication that was made to us by the claimant that we didn't put much stock into? So I guess my answer to you is, because all of us lawyers like to talk, my answer to you is, it really depends upon how much work you're doing on the case immediately after retention. Because if you're doing any work on the case, then that means it really did satisfy the basic retention threshold to have your team begin an investigation.
Hey, Gary, it's a little different with our practice, and we've seen numbers in some cases 2-3 times that, 20-30%, because we don't have the accident report. As you well know, clients lie. They all think, the other party was at fault. Some states like Paul's are, 1% contrib. You have single vehicle issues. With the motorcycle case, there's a lot of nuance and issues that contribute to having to basically fizzle the case or no fee the case. So we've seen it, 20-30% on average. But
so, and by the way, and Ari, so I can't have an opinion. So the question becomes, what's your tolerance for it then, right? Because I'm never going to stand here and go, Ari, well, we shouldn't have signed that because we didn't have a photograph of the scene of the accident, right? Of course not, right? Because at the end of the day, if you're saying, Gary, there's some investigation has to go on in these cases, and I'm going to go back to what I said in my book is, then sign, then investigate. Don't investigate, then sign exactly what you're saying, and maybe that 20 to 30% is okay because you're talking about higher value cases anyway, so it justifies all the cases you're rejecting.
Hey, Gary, can I ask you another question?
Of course.
When you were talking about, I will tell you, I think when you were talking, well, first off, can I get a copy of that one slide, or can you share that one slide where all the things we do wrong? I guess it was like 16 different little boxes or whatever it was. I'm sure you found the title of that slide. I'd love to have just that one slide to kind of share with the intake team.
We'll make sure it gets sent, but not only a recording of this to everybody, but a copy of that slide as well.
Yeah, the other thing, which I have found to be just immeasurable when talking to a new client is, as you're aware, many times the client has diarrhea of the mouth, the new caller, and they just talk, and you literally need to grab control of that, or you're going to spend too much time on the phone, where you give that roadmap, that little key to how this conversation is going to roll. We're defining roles. I'm telling you what I'm doing. It's so comforting to the caller. And then you get exactly what you need, because my objective is they're all firemen or firewomen, and they have to be, I want them on the phone and have the investigator sign up or have it e-signed, and then get off the phone so you're ready to put out that next fire. But one of the words that you used, which I don't know, it's me a little bit weird, is the qualification rule. And you're saying, okay, Mr. Jones, let me see, it seems like you qualify. I'm not sure if you qualify. Okay, you definitely qualify. That word to me sounds, I don't know, it's a little bizarre to me. Do you find any pushback, or do you have a better word for, or do you just say your case qualifies as opposed to making it personal that, you don't qualify? It sounds like I'm inadequate, and I hear that enough already, so I don't need to hear it again.
So first of all, thank you. And I think that, yes, you can articulate that so much better. I was so quick to say it that way, but at the end of the day, it's really, Mrs. Jones, based upon everything you just told me, we can help you, right? So like, the tougher part is when you can't help them, and you have to give them something, because you're never gonna say, sorry, you can't help, it's not gonna work that way. So you gotta give our people some language to be able to disqualify the case, but you're not gonna say you're disqualified. And I would stay away from saying, maybe in my example, I use the word qualify, but you don't have to use that. It's not the best way to articulate that. Rather, it's based on everything you just told me, we can help you, right? We can help you. It's exactly what we do every single day. And all you have to, in order to get things started, something I didn't say, which you just jogged my memory. We need to tell claimants to manage expectations, which is how you start off what you just told me. To manage expectations, we have to tell claimants that when you sign this document, you're giving us the authority to begin an investigation on your behalf. That's what this is. It's not, hey, once you sign this document, we're going to get you money. We cannot begin an investigation. This is how you convince them to sign. We cannot begin an investigation on your behalf until you sign this document. I can't call your doctor. I can't reach out to the police station. I can't do anything until you give me authority to represent you. Right now, I want to start that investigation today. So I'll stay on the phone. I'll wait for you to sign this, and I'll begin that investigation. But now to go full circle to what you said, Paul, I think humanity, with how fast we're moving, we're doing such a terrible job at managing each other's expectations. Terrible job. So if you can, at the outset of a phone call, let a claimant know, here's how this is going to go down, right? Not using those words, right? Here's what to expect from this phone call. Here are the questions I'm going to ask you. Here's the information I'm going to gather from you. And then by the end of this call, I'm going to tell you whether we think we can help you. And if we can help you, I'm also going to tell you how we can get started today. If you can get that out in the beginning, they're now in their mind going, got it. And then in their mind, they also say, okay, I just gave my contacts. Now they're going to ask me some other, okay, here are the other questions. All right, give them the answers. Now they're going to tell me whether, boom, now they want me to sign. And now they're going to get, now in their mind, they know exactly what to expect. The alternative is keeping them very uncomfortable. And quite frankly, could be the difference between signing a case and losing a case.
Paul, any other questions you have? No? Anyone else have questions for Gary?
Lee Coleman, can you hear me? I have a question.
Hey, Lee, how are you?
Hey, Lee.
I'm good. So, Gary, just a little qualification for the question. We have well-known brands in our market where we're Law Tigers in Tennessee. We're a large advertiser in Nashville, so we hope that most people in Nashville have heard of Hughes & Coleman. But when a call comes in to us, a hot transfer from Law Tigers, the caller didn't call for Hughes & Coleman. They called for Law Tigers. So two things. One, would you think there should be any lower conversion rate because of that change versus, I mean, we know what our Hughes & Coleman conversion rate is, somewhere 92, 93% generally. We work hard on keep that up. I haven't looked specifically at the Law Tigers conversion rate. It's hard, there's a lower sample size, so it's hard to know, if it's reliable, but should it be lower because of that? And if so, how much lower, is acceptable, 5% less or what? And then do you have any tips for what we can do, what we can train our intake staff to do, so when somebody calls and the call comes in transferred from Law Tigers, they tell them it's Hughes & Coleman, but if they're going to get some sort of question, just from your experience with intake, any tips you can think of that might help us increase that conversion rate? And the final thing I will say on that is, we in the past have bought a lot of mass tort leads, and for a while, and one thing we found in buying mass tort leads, they didn't look for Hughes & Coleman. They just went on the internet, clicked some buttons, and we end up buying the lead. And our closed, the rated cases we end up closing because the clients were uncooperative was much higher than the people who wanted to call, intended to contact Hughes & Coleman. So I guess I'm looking for any tips with to manage the Law Tigers callers, so we don't lose them because they didn't intend initially to call Hughes & Coleman. Your thoughts?
Yeah, a few things. One, I would say at the outset, for sure, it's probably gonna be a lower conversion rate because it's a different brand. But I think you can train your team to make it really close, if not equal, your current conversion rate. If you tackle that issue without it being brought up by the claimant. If you could get that lead and say, this is, and you yourself introduce yourselves as Law Tigers, Law Tigers with Hughes & Coleman, and then say, just so you know, Law Tigers has a national brand, and depending upon where you are, it's going to be a different law firm, and you guys can articulate this better. This is just me off the top of my head. And you let them know at the outset that this is Law Tigers. It just happens to be Hughes & Coleman with Law Tigers. I think it's going to help you, and you probably do this and probably do it well, help you in the long run so they don't have any questions moving on or in the future. I do think that the number could be very close Lee. Maybe not in the beginning when you're first doing it, because your team has to know this is a Law Tigers lead. This is how we tackle that issue at the outset. And then if there are any follow-up questions, here are the potential follow-up questions from our experience. This is how we get over them. So I think that stuff needs to be trained well, but I don't think it's insurmountable. To answer your other questions with the mass torts, mass torts is funny because branding becomes less important with mass torts unless they're looking for your law firm. If they're looking for your law firm and they're wondering whether your law firm does that mass tort, that's one thing. That's really the minority of time. Very few law firms, very few, have such a tremendous mass tort value, brand value, that people look just for them for mass torts. Usually it's someone looking for a mass tort, looking for a case type. A law firm pops up and you're going to have to do a much better job at explaining to the claimant that you're a leading litigator for those mass torts, and explaining how many claimants you have and how heavily involved, how many resources, maybe not how many claimants, but how many resources you have at your disposal to get success for that claimant. So I do think, as I said earlier, mass torts is going to have a lower conversion rate. It could, if you're good, it could be as high as 80, 85%. If you're not good, it could be lower than 50%. So you have to be, it's a different animal for sure.
All right. And then thank you. That's good information. Ari, from your end, are you close to being able to release any information to the firms about what conversion rate you're seeing at different firms? If we share our Law Tigers conversion rate, I'd be curious to know, what Paul and Rick and the guys I know, what their conversion rate is. And are you going to be able to do that anytime soon? Or maybe you're doing it now and I haven't seen it.
Yeah, we're Tiff and I have been working together to put together as well as with you guys and Rick's folks, some reporting on that. So we should have it within the next month or two to share, probably on one of these webinars, because I know that's important. So yeah, it's in the works, and it will be done in the next month or two.
Sounds good.
Hey, Lee, along the lines of what you say, I mean, I personally handle every Law Tigers case in our office. And when I call, or when those calls come in, just to bounce a little bit off of Gary, we actually say, "Hi, thanks for calling the Law Tigers division at Kalfas and Nachman." And I'll be honest with you, when we tell them so far, and I'm telling you the ones I've heard, I can't imagine, look, I'm sure it has happened, but I'm not aware of any time that somebody's reached out to us, and when they found out it was Kalfas and Nachman, they said, "Hell no, I'm going somewhere else." They're actually reassured because there's already so much ubiquity with the firm, as well as your firm and your DMAs, that they're like, "Oh, I'm familiar with them," and that's great. So even when I call at any point in time, I go, "Hey Gary, it's Paul Hernandez calling from the Law Tigers division at Kalfas and Nachman," and they go, "Hey Paul, what's going on?" So I'll tell you, I think number one, I don't think anybody's going to say, "Oh, it's Hughes and Coleman, I'm not going to go with them," and they actually probably feel better about it. But lastly, I mean, the way it works for us is, hey, it's Paul Hernandez from the Law Tigers division at Kalfas and Nachman. So I'm just telling you what works for us. I
like that. Thank you. That's good. That's a good tip.
I think my dad does the same thing. He incorporates Law Tigers and Lebanon as well. Anyone else have questions for Gary?
Gary left, I think.
Oh, Gary left?
Maybe not intentionally, but that's what it said.
Oh, may have been cut off. Tiffany, do you want to see if what happened with Gary real quick?
Yeah, let me see.
He may have gotten. Did he get cut off?
Let me see.
I just got 1 or 2 more questions for him, for the benefit of everybody here. I'm sure I'll call him real quick to see where he's at.
Okay. Does anybody have any other questions that maybe, I know Ari said that we're working on getting some of the data together. So if you have any questions or
come back in, we have a couple
need
more.
anything, just let me know.
see if I can do it on my phone.
Yeah, you can do it on your phone.
I think it's me. I think the internet's down or something over here.
You want to do it on your phone real quick?
Yeah, can you, yes, 30 seconds. I'll go ahead.
Okay, thanks. All right.
Why don't you, okay.
He lost his internet connection. He's going to call in on his phone. He'll be here momentarily. Just so everyone's aware, while we're getting Gary back on, we will make sure that everybody gets a link to this presentation. Tiffany has been recording it. We'll also get you an image of that slide with all the I think the 16 or so different checkoff points that he referenced. And then in terms of Lee's question, that is something that we've been working diligently on, is getting all the data from members so that we can share want rates, close without fee rates, close with fee. Hold on, that's him. Hey there. Yeah. Sure. So, any other questions? Gary says that he's having a hard time getting through. Are there any other questions that I'll put him on speaker here? Maybe we can pick it up. Any other questions for Gary? I have a couple quick ones, Gary. One of them is how often should we be following up with clients that we sign in terms of frequency?
Oh, I love that one. Guys, I cannot tell you how many law firms, how many cases are being lost because law firms think, well, they signed it, so they're obviously not going anywhere. In mass tort specifically, there's a dual rep issue that is prevalent within our industry because law firms do not provide the bare minimal customer service that is necessary to keep a client happy. And we all know how valuable a happy client can be. So the answer is there better be a post-retention welcome call that your team has and implements so that the same day, if not the next day, the same day, the claimant gets a phone call welcoming them to the law firm, and then again, managing expectations and creating a roadmap for what's to come post-retention. That call has to happen. And then I would say, in the beginning, there probably should be an every couple of months check-in call to make sure the claimant knows that they're in good hands, see if there's any update on the case. But this is something, especially higher volume law firms, they're losing. And they're not, and the thing is, forget about losing claimants to other law firms. You're losing value on your case because you're not speaking to your claimants enough to actually know maybe what type of medical treatment they're getting, maybe a new doctor that they're seeing. Maybe there's new instructions that the doctor provided to them. Maybe they're moving, and now you're going to have a hard time finding out where they moved to. So, to answer your question, immediately, when upon a case getting signed, there should be a welcoming call and a roadmap for what happens when you become a new client. And then after that, every month to 2 months, there should be a check-in call, regardless of whatever else you need from the client.
Okay, and a follow-up question: those that are not signed, that we want, how should there be a certain number of follow-up emails and calls to try to close that or get that client to sign up or that claimant to sign up?
It should be at least a month. And you're going to want texts, you're going to want phone calls, you're going to want emails. And once you speak, by the way, I say at least a month. Sometimes you speak with a claimant and there is so much going on in their life, it could be 6 months. We've done that in mass torts many times. But you should not give up on a qualified case for at least 30 days, unless they tell you otherwise.
And is there,
tells you,
how about frequency, cadence on the text, emails, and calls? Is it once a day, once a week for that month? How often should that correspondence be going out?
Yeah. So in the beginning, you want to follow up. There's not like one general rule because a lot of it depends upon maybe what did you send an electronic retainer out? Did you send a mail out, a retainer out? Did you have somebody meet with them? But quite frankly, it's got to be multiple times per week and through multiple methods. And sometimes you have to change the voice too. I would have a lawyer call up. I did this back in the day at Parker Wakeman, where I would get a list of cases that we were about to close out that were qualified. And I would call them and say, hey, Mrs. Jones, this is Gary Falcowitz. I'm a managing attorney here I know we've been trying. I know you qualified. Spoke with one of our team members a couple of months ago. We had a hard time getting in touch with you, but I'm an attorney, and if you have any questions, maybe I can answer them for you. I know that we think we can help you. And then she called me right back. That was a voicemail. And she goes, you know what? I just didn't think there were any lawyers involved in the firm. I kept speaking to an intake specialist, and I didn't think this was real, right? And we signed that case that day. Does that mean it's going to happen all the time? Of course not. But sometimes a new voice and one with authority may have more of an impact on a case you're about to give up on.
Great. One last question. If firms want to train their intake people, are there opportunities either with you or someone else to come in and work with the intake staff on all the things you covered today?
Of course. Yeah. I mean, I mean, in this COVID world, I've slowed down my consulting significantly for this reason. But yes, I've worked with many law firms throughout the country. When I go in, I look at what they're doing and I tell them how they can do it better. I tell them what they're doing well, but it usually has a direct and significant impact on their revenue at the end of the day. And plus, it's always nice to have an objective eye come in to see what's under the hood.
And what other services do you offer, just in case anyone's interested?
Oh, so the big one right now is my call center, an outsourced intake department. So if you're running any high volume mass torts, class actions, employment, whatever, things of that nature cases, most law firms do not have the resources internally to do it themselves. So they outsource the intake to my team, and it's something that we've done really, really well with for law firms throughout the country.
Great. Anyone have any last questions for Gary before we conclude? All righty. Well, thank you, Gary, very much for your time. Appreciate you taking an hour and a half out of your day to speak with us, and we'll make sure to provide your information to everybody else or anybody who's interested. Okay.
My pleasure. Thank you guys for your time. Hope it was valuable to you. Have a great day.
Thank you, Gary. It was great.
And again, want to thank all of our Law Tiger team members for participating. Hopefully you saw value in this. If there's anything else we can provide with respect to intake, please let us know. And lastly, if there's other subject matter that you'd like us to address in these monthly webinars that Tiffany puts together, please let her know. We'll get you the information. And our goal is to obviously make you successful and increase your intake conversion and make these clients happy so they tell other people to call us. So that's all I've got. Tiffany, I'll give you the floor.
Thank you, Ari. Everyone, just send any subject matter that you think would be relevant, and I look forward to seeing you guys next month, third Wednesday of the month. Thank you.
Thank you very much. Have a good one.
Bye.
Bye.